In addition to having the ability to retire, most individuals don't have that ability, and they're at significantly lower years. They don't have the ability to retire. They can submit what's called an unqualified resignation, which means they're resigning their commission from the military. And when I say unqualified, it's unqualified because you do not get to have a say as to whether it's going to be an honorable, a general, or an other than honorable type of discharge. Now, we've made a lot of videos on the different types of discharges. You can look those up online fairly easily as to what benefits you receive at an honorable, a general under honorable conditions, or an other than honorable. Once you submit that unqualified resignation, it goes up to, now I'll use the Army term, it goes up to HRC or Human Resources Command, and they're going to look at it, look at the alleged misconduct, look at your file, look at your performance. They're going to look at a whole host of factors and make a determination as to what type of discharge you should receive. If you're submitting a resignation in lieu of a BOI or a resignation in lieu of a Army show cause board, you're very rarely going to receive an honorable discharge. Now, you may know if you've got a V device, on your chest, or you've got significant combat experience, and you've done some heroic shit for the military, then you very well may get an honorable discharge and may override what you received the GO mark for. But that's the exception and not the rule. Typically what we're seeing is general under honorable conditions or an OTH, depending on the severity of the misconduct. In the scenario where I used, where you have a lieutenant colonel who committed BAH fraud, and let's say the fraud was for $45,000, you're probably going to get an OTH because the Army's going to look at this, or the military is going to look at this and say, you stole $45,000 or whatever that amount was. You're probably not going to get a general under honorable discharge, although it's possible. It's going to be based on your service record, the misconduct, and so on. But that's the unqualified resignation. That process may take 6 months to 12 months to play out. So once you submit your unqualified resignation, it's not like you submit it and a week later you're out of the military. It's typical military hurry up and wait. You have typically 30 days to submit your elections. And if you may submit your elections the next day, or you may submit them within that 30-day period, but you're likely going to be waiting 6 to 12 months to find out what happened. Once that resignation is accepted, you're going to get orders to be processing out of the military very, very quickly. So that is option 2 if you're required to show cause just for retention in the military. Option 3 is where we really live and breathe and where people retain us, and that's to fight these at a show cause board. And so you can elect to have your case heard by a show cause board as long as you are not a probationary officer. So if you're a probationary officer, you don't have a right to a show cause board. So if you are or not, but if you are a probationary officer, you do not have a right to a show cause board. You have a right to just submit written rebuttal matters. And that's about the best you're going to do. But for this discussion, let's assume that you are a non-probationary officer, because that's the vast majority of individuals we talk to are just standard officers who are not probationary officers. You submit to elect to go to a BOI or a board of inquiry. So when a board of inquiry, what's going to happen is once you elect a board of inquiry, then you have a right to an administrative hearing. And this is an administrative hearing where a board of officers who are required to outrank you are going to have a hearing. This could be a 1-day, 2-day, I've seen 3- and 4-day hearings, where it's going to be evidence collecting. They're going to do written findings of fact and make a recommendation as to your separation or retention. So once you submit a request for a board, typically a board will be convened. That takes about 30 days in terms of time frame on it. Once you submit your request, it's usually 30 days before a board gets appointed. Those board members are always going to outrank you. Typically what we're going to have is an 06 and 205s. We might have a major on there, but they're always going to outrank you. And if you're a warrant officer, typically you're going to have a W4 or maybe a W3, but they're always going to outrank you. From the time the board is appointed, you have a 60-day time requirement to do the board. And so if you're thinking of time frame, you receive your notification, you request an election of a board, you're typically 30 days out. From there, you have 60 days. So you're usually going to have 90 days from notification of a requirement to show cause up into the actual board itself, sometime in that time frame. At the board, this is what people hire us to do. We fly all around the world to do these boards because these boards may make the difference between being able to stay in the military and not. So if you have a case where you have a lieutenant colonel, for example, who has 17 years of service in, and they get kicked out at year 17 and a half, they've essentially lost the ability to retire. So this board can be the financial equivalent of millions of dollars in retirement for them, or the ability to have all of those benefits. So these boards can mean a great deal, not just for your ability to stay in the military, to fight for what you've earned, to be able to retire with honor, but also there's a massive financial piece to this for the respondent or the military service member. And even for those individuals who are not at 16 or 17 years, people work their butts off to get a commission and to join the military. And in particular, if you've been falsely accused of something you didn't do, you received a GOMAR, no one read your rebuttal, now you're going to a board, you need to fight this because the board is absolutely your best opportunity to have your side of the case be heard, and it's your best chance to win, bar none. If you've been notified of an administrative separation board or a BOI, I want you to understand that you can absolutely fight this, regardless of whether your GOMAR was permanently filed or you're previously found guilty at NJP or Article 15. If you have a right to a board, get in front of these board members and fight. You can win these cases at a board. We do this routinely. If you want to have a conversation about how to do that, give me a call, 813-669-3500, or look at the information we have on our website, www.bileckilawgroup.com.